Hello and welcome to The Leading Question. I'm your host, Steve Wigreiser. Joining us today is Professor Cathy Rosen from Philadelphia's Temple University, the Department of Criminal Justice. Very excited to have Professor Rosen here. Welcome to the show.
Thank you.
And today's question concerns the criminal law, and we've spoken on many occasions about the difference between the civil justice system and the criminal justice system. As most of you know, I'm involved in the civil justice system where victims of negligence, victims of malpractice can seek and receive a compensation for their injuries and their damage. But the defendants, the people we bring claims against in our cases, are not punished. They're not sent to jail. Typically, there's no probation, there's no loss of license, etc. And that is in distinction with the criminal justice system, where there is a punitive remedy that hangs over the heads of those who are accused. And so today's leading question is this: Is it possible, Professor Rosen, to reconcile the desire on the part of many citizens for stepped up or tougher law enforcement with the very, very important rights of the accused, the constitutional rights of the accused? Is it an either-or proposition, or is it possible to reconcile the two? To my way of thinking, and I don't practice in your area of expertise, if you emphasize one, and we hear candidates talking all the time, oh, I'm a law and order candidate, etc., are we necessarily sacrificing constitutional protections of the accused? And even though most candidates, and for reasons that I think are obvious, don't typically emphasize the rights of the accused, we do hear about that from time to time on particular issues such as stop and frisk, which we'll talk about. But can both these goals be realized in our system as it's currently structured?
I think the answer is not a clear yes or no. And the reason for that is the sheer volume of our system. The reality of our system is that the model that most of us are familiar with, which is what we see on TV shows or read about in books, true crime books and that sort of thing, is really a very formalized system of a full-blown felony trial for a serious crime. And in that version, that entity, that part of the criminal justice system, people do, for the most part, get guaranteed their full rights, right? And those are the crimes that I think the public is largely concerned about, too. The murders, the armed robberies, the sexual assaults, the crimes that really threaten our safety. Then there's the low-level crimes, the crimes that don't threaten our safety so much, but make us feel really insecure, like retail theft, simple assaults, drug crimes of various sorts. For those crimes, they're really being treated in a very different way in the system. For the most, they're treated in the misdemeanor courts. For the most part, people are just kind of processed through what some people have analogized to an assembly line kind of situation, where you're charged, you're brought to court, you may or may not be released on bail, you get an attorney, the attorney's appointed, you see the attorney maybe at your first appearance, you're encouraged to plead guilty for a whole host of reasons, and in that sense, you're really never getting the opportunity. You get your right to attorney, you waive your rights when you plead guilty, but you're never really getting the opportunity to test the evidence, to make sure that everything is on the up and up. And so we're not getting a lot of due process, if you will, at that stage.
It sounds like in the smaller cases, we are providing constitutional protections light. Is that a reasonable description of what's going on here?
Yeah, I think that's a great way of characterizing it.
The heavier crimes that you've alluded to, the homicides and the rapes, etc., the ones where there is more at stake for the accused, and I don't want to judge the difference in sentencing, because all sentencing is a very negative thing for the accused. But it seems to me that where there is more at stake, perhaps there is more in the way of protections afforded. Is that inaccurate?
I think that's accurate to a degree. Okay. Because the reality is that only about 5% of all cases actually go to trial. So 95% of cases are resolved by guilty pleas.
So it's not like Law and Order, where they all go to trial and you get a result and it all happens within 30 minutes or 60 minutes.
Oh, no, absolutely not. Absolutely not. And in fact, as we all know, sometimes it can take much longer. But the reality, again, the reality is that most cases are resulting guilty pleas. And the fact is that the system would blow up. It would, self-immolate if we had much larger an extent of actual trials. But in those more serious cases where more is at stake, there are more processes that one goes through even before reaching this point where they plead guilty, oftentimes. So the evidence is often more likely to be tested. There'll be time for what we call pretrial motions, which are opportunities to challenge the voluntary nature of a confession, for example,
right.
To challenge the police action in searches and seizures, and if there allegedly are constitutional violations, that sort of thing. But in the long run, you plead guilty, even if there's not a plea bargain per se. It's widely recognized and known that pleading guilty is going to give you a lighter penalty than if you went to trial and were convicted. So we kind of refer to that oftentimes as the trial penalty.
The inducement to plead guilty.
The inducement to plead guilty, is that you won't be faced with the so-called trial penalty, which is that if you put the system through the cost and expense of putting you to trial and you're found guilty anyhow, you're gonna pay for that in some sense of the way in nature of your sentence.
Very interesting. If everybody exercised their right to question everything at every step in the process, we would have to double the number of judges and courtrooms and perhaps prisons.
Doubling is, I think, an understatement, right? But it would be even greater than that, because people have described the system as a pyramid. Right? At the bottom, at the base of the pyramid are the misdemeanor cases, right? Which aren't very serious. They often involve people of color, people who are at the lower end of the socioeconomic scale. And then as you move up to the pinnacle, you get those cases like against President Trump, right, that are kind of these renowned epitome cases or famous murders, O.J. Simpson, Bill Cosby, right? They're not necessarily all involving celebrities, but they're very serious cases and often involving people who have financial resources, because the reality is that to fully avail yourself of the constitutional protections that the system provides, you need money. You need resources. It's not just the quality of lawyers that might vary, based on what you can pay for, but the ability to investigate, the ability to, in the biggest cases, and I'm sure you know about this from the civil system, use trial consultants, as in the O.J. Simpson case, where they were used to great renown. All of that depends upon one's resources.
Bringing in experts, scientific analysis, guidance with jury selection. I mean, that is very expensive. We have to pay it in our cases,
right.
But it's not unusual in our cases to spend 6 figures just to get the case to the courtroom, and then of course that doubles once we get to the courtroom. And I'm imagining that the average individual can't do that. The average criminal lawyer can't work on a contingent fee basis like we do, because there's no compensation coming. And all of these things promote what I'll call nicely efficiencies in the process. And so really the question is this, and if I can label what you've described as rough justice, and I don't mean to be pejorative, right? Can rough justice still be good justice or good enough justice?
Well,
in your view?
Yeah, that's the $1,000,000 question, I think.
That's why I asked it.
And so, and it's a question that's hard to get a handle on, right? We know that innocent people end up being convicted of crimes they didn't commit at times. We started to learn or be certain of in serious cases like homicide and sexual assault, once we had DNA technology that could go back, look at old cases. Sexual assault is the prime example, where there had been samples of bodily fluids that had been connected to defendants based on blood type. And we all know that, I think there are 3 kinds of blood type. Might be a little wrong there, but huge percentages of the population have each of those blood types. So just to say it's the same blood type, well, you could exclude it by the wrong blood type, but saying it's the same blood type doesn't do anything. Once we were able to go back and use DNA testing, we were able to find that there were people who had been convicted of serious rapes who were excluded by DNA testing, who could not have been the offender, right? And so that started people questioning, are there maybe other places in which the system there are errors in the system? Just as an aside, the DNA problem has become better lately. There have been in the last few years, there are fewer DNA exonerations as DNA testing has become a regular process in the investigation of sexual assaults and other crimes where there's bodily fluids that may be able to be used for that.
So there are fewer convictions, therefore fewer exonerations, because there are fewer wrongfully accused.
Exactly.
Wrongfully convicted.
Exactly.
Okay.
So that's one of the places where, actually forensics have helped prevent erroneous convictions. We have these mistakes where we can prove actual innocence. We know that there's other instances of false confessions, mistaken witness identification, issues with forensics, other kinds of forensics than DNA that have also led to people who have later, new evidence has shown to be innocent of crimes. But what we know about are largely the serious crimes. At the misdemeanor level, the question becomes much more complicated because we don't have the incentives to go back and challenge the convictions. Challenging a conviction can take years. It needs to get people on your side. A lot of the Innocence Project people, the innocence attorneys, will only take cases in which they're really going to save someone from having been incarcerated for a long time, that sort of, or perhaps from a death penalty even.
All felony cases.
Yeah, felony cases with serious penalties. And the misdemeanor level, we just don't know. But what we have to assume is because of the nature of the justice there, that there are, and the fact that there are tremendous incentives for people, even if they say, if they're innocent, if they say, I didn't do it, right? There are tremendous incentives to just plead guilty and get it over with. So we can assume, and people who, legal scholars who have worked in the misdemeanor courts will verify that indeed there are many, many cases in which if people had challenged and availed themselves of the full panoply of opportunities to challenge the evidence, go to trial, that sort of thing, that they may well have been freed, or they may well have been innocent. For example, a Professor Alexander Nadapoff, who worked as a federal prosecutor in the Baltimore misdemeanor courts, talks about how at one point, a decade or so ago, the Baltimore police would go out and just round up people who they suspected of drug dealing and carrying guns and those sorts of things. You know, groups of people on corners, that sort of thing, and charge them with loitering.
Right.
Well, none of these people, or many of these people, I won't say none of them, had actually met the statutory definition of loitering under Maryland law. But yet, they'd be hauled in, they'd be incarcerated, they might have had a high bail set. And so for them, the value proposition is just plead guilty. I'll be on probation, but I'll go home right away, right? And
but there may be implications to doing that when later down the road a misdemeanor is still on your record unless it's expunged. I'm thinking of an experience where a close family member was caught up in one of those speed traps and showed up for, I guess it was the district magistrate's court. If you're willing to plead guilty to traveling 5 miles an hour over the speed limit, we can process you now and you'll be out in 15 minutes. It was expedient. It didn't cost them anything, didn't cost them time from work. And I'm sensing some sort of analogy here. What do you think?
Oh, there's an absolute analogy. Except that what we also have are people who are living much more precariously than probably the people who were in this
Villanova.
Exactly.
Yeah.
So, you know, in the Philadelphia Municipal Court, you have people who are living very precariously, who can't miss a day of work, who children might be left alone, you know, whatever the case may be.
Right.
And so for them, the incentives are much higher, but probably the potential costs are much higher as well.
Right.
Because now they have a conviction on their record. And so next time they have an encounter with the criminal justice system, which is likely to happen because of the nature of their circumstances, right? They will have this conviction on their record, and you can't go back and say, oh, wait, you know, I just did that because I needed to get, I didn't want to lose my job,
right,
or whatever it may be.
And the judge goes through, I'll say, a pro forma voir dire. Do you understand what you've been accused of? Do you understand that you have the right to plead not guilty and proceed to trial? Do you understand that you have a right to a lawyer? And in order to get the guilty plea to the misdemeanor, you have to say yes to everything. No doubt and I don't mean to cast aspersions at public defenders, but no doubt that's the advice that's being given to their clients. And so they can't go back. That's all in the record. There's a record of them having fully understood their rights and making an informed decision.
Absolutely. And yeah, once a client decides to plead guilty, any lawyer is going to say, okay, just answer yes to every question. And if they have time, which they may or may not, at the lowest levels of the misdemeanor courts, they'll go over the colloquy with them, kind of practice. In the lowest levels, they're meeting this person, you know, for an early guilty plea just because they want to get out when they can't raise bail or whatever. They're meeting this person in the courtroom, you know, at a preliminary hearing, and the person is saying, okay, I'll plead guilty, right? And so they're going through it very, very quickly. One of the one of the criticisms is because, again, they're guilty pleas for serious felonies all the time too.
Sure.
And one of the, and some of those guilty pleas, even though a guilty plea basically is a confession of guilt, it's turned out that people who plead guilty are sometimes also innocent of the crimes that they've pled guilty to, even the serious crimes. And so one of the suggestions for reform is that judges, when they accept guilty pleas, demand more of a factual record to support the plea and be more critical of that. So the way a guilty plea, you don't just plead guilty, the prosecutor has to recite some evidence that shows that the person committed the crime. And it can be very pro forma. There's no challenge to that evidence, right? There's no right to cross-examination. The defense doesn't give their version of the story. But one of the suggestions is that demanding more evidence and the judge taking a more critical look at the evidence, because that's all the judge knows. The judge doesn't have this whole record of the investigation of the case.
Sure. So the facts come out.
What the judge does have the authority to do is to reject the guilty plea.
The problem with the proposals and suggestions that you've mentioned, and I'm not labeling them ivory tower suggestions, but some might, is that you're now messing with a judge's docket. Judge has 75 cases that have to be cleared on Monday because there's 75 more coming in on Tuesday. And if you want me to spend an additional 15 minutes with each individual who has an attorney, then the system begins to break down a little bit. And I think that that's something, and I know there are judges in academia, and I know that there's interaction. But I think these are the kinds of things, whether they're said or not said, that are realistic motivators to the efficient administration of justice, if I can say that.
Absolutely. And that time and money are driving everyone.
That's right.
They're driving the judge, they're driving the prosecutor, and they're driving the defense attorney, whether it's a public defender or a private defense attorney. Again, unless you're at those highest echelons, because the private defense attorney isn't getting paid very much either. And he or she have a lot of cases in order to make enough money to survive.
That's right.
And, so they have to, that's a whole other thing. But so, maybe one of the answers, if we get back to your original question, which is, well, the public wants law and order, right? They want to see people, pay for their crimes, or at least the punishments be high enough that they theoretically deter the crimes, which doesn't work, a whole other topic. Yeah. But anyhow, maybe one of the answers is, well, we need to dedicate more money to the criminal justice system, have more judges, pay public defenders better, be able to provide forensics help to both sides, or have more qualified forensic scientists who work for the government usually, etc. So maybe that's part of the answer.
But you have to buy into the proposition, and I'm going to butcher this because I don't remember where it comes from, but it is better for 10 guilty people to walk free than one innocent person be in prison. The face of the criminal justice system for most people is the police officer, the cop on the beat. In some cases, the neighborhood police officer, but frequently not. You've been looking at these issues. You've written for police officers. You've studied policing. In your view, is it more difficult to be a police officer today than it was when you first started teaching and studying criminal justice?
Probably, and that's just because, I would say that only because I think there's more public discourse, more political discourse focused on policing. I think and I think the other problem is there's more guns. And the fact that there are so many more guns out there, at least from a police officer perspective, makes their job that much more dangerous. So I think we have those kind of two very distinct things that make the job harder. One is that people are more likely to be anti-police, see the police as oppressors, etc., and also that the police perceive of their job as being more dangerous, although I think they always thought of it as being dangerous. So it's just that greater number of guns out there.
It seems to me that when I turn on the news, police departments are always telling us that it's very difficult to hire enough police officers, and we want to increase police officers in some cities. So I presumed it may have something to do with the lack of respect police officers now feel. Similar question. Do you believe that community norms and expectations should guide law enforcement?
I think that for law enforcement to be effective, there has to be a buy-in to what we call community-based policing or community-oriented policing, right? Where the officers need to understand the community that they're working in, and they need to be seen as cooperating with the law and order needs or the security needs of that community.
I'm not talking about crimes with victims. I'm talking about the panoply of victimless crimes like noise ordinances, open containers, marijuana use, if it's still illegal in Pennsylvania, I can't remember, et cetera, et cetera. Well,
I think it is.
Okay, because it seems to me that what is too much noise at Broad and Shunk may be different than it is at Broad and Pine or Broad and Diamond or Broad and Cheltenham. And so if the police are attuned to the community thinking about that, then perhaps law enforcement has more credibility when it comes to other matters. What is your thinking about that?
Well, I think that helps, but I think that what you've pointed out is kind of the tremendous discretion that some of these low-level crimes like noise ordinances or vagrancy or loitering, an example we used before, or even possession of marijuana, create for law enforcement, right? They can't, just as if we use the example that everybody's more familiar with of driving, virtually everyone drives, they can't possibly enforce the law against all the people who speed, right? We all have our rule of thumb. You can go 10 miles over the speed limit, right? Whatever your rule of thumb may be. But they can't possibly enforce because nobody's following that law. So they have to make decisions, right? And it's the way they make those decisions that starts to become questionable, right? And that starts to lead to accusations of racial profiling, of unfair enforcement, etc. The fact that police, it seems to people, and statistical evidence backs this up, shows this, that police are more than likely to stop people of color, men of color, particularly young men of color, that they're more likely to, once they've stopped them, whether it's in a car or as pedestrians in what we call a stop and frisk, that they're more likely to engage in a search, which may or may not be legal, and that they're more likely to, then arrest them if they find anything or any reason to arrest them and bring them in, and then the person is now involved in the misdemeanor system.
Understood. I want you to know it was a pleasure to have you.
Thank you. It was a pleasure to be here.
I hope that you will come back. A number of topics I'm interested in talking about. And to our viewers, stay interested, stay involved, and don't be afraid to ask the leading question. See you next show.